of our country's constitution adumbrates very clearly that an accused person is innocent until proved guilty, or until that accused person has pleaded guilty. Your Honor, none of those two critical conditions prescribed by the Constitution has happened. So, to say that he could be handed down a 14-year sentence is to adjudge him guilty. And we have not gotten to that place at all. I don't even think we shall get to that place. Your Honor, the accused person is not trying to evade prosecution. And that is why we have presented very credible sureties. The accused person is a responsible member of society, a leader at that. He is saying he has no problem with being prosecuted. He's simply asking for temporary freedom on bail to be available as and when court does require him for trial. The rights of this accused person are very paramount, as we have stated, including the right to apply for bail. This person has been behind bars for quite a bit of time, and we have made commitment, the sureties have made commitment, this accused person will be in court as and when court does require him to show up. With these unnecessarily stringent conditions which are being suggested by our colleague in the state. Our prayer again, Your Honor, he will be available whenever court does require him to be available. Hopefully, the state will be ready for trial because we are ready whenever that gets to happen. So pray, Lord.
The state's claim of the likelihood of interference with witnesses must be backed by evidence. There is none on record. The law requires that an allegation about the likelihood of interference with witnesses must be backed by evidence of record. There is none, and therefore that should be rejected. Your Honor, the fear of abscondment is never cured by imposing a onerous bail terms, but by providing a non-cash bond on the shoulder.
Don't talk to me like that.
So basically that is the video. I think they had applied for bail, but I think they refused. So you can see, let's first see what is happening here, what this video is all about. Update, we are saying John Mary Ssebuwufu, deputy spokesperson. No, Mary Ssebuwufu, deputy chairperson of the National Unity Platform NUP Election Management Committee. So he's the deputy chairperson of the National Unity Platform Election Management Committee. He has appeared before Nakawa Magistrates Court seeking bail on charges of incitement of violence. So, according to his lawyer, Ssenyonyi, so it is Ssenyonyi in this case, Ssebuwufu is not attempting to evade prosecution, but is requesting temporary freedom as he awaits trial. The court has further remanded him and will deliver its ruling on the bail application on March 24th, 2026. So, bazagarika ebirabiri nabyo kwa kashatu. So in other words, they wanted bail for him, and unfortunately it was not given. So okay, what do you think about this? Let's look at different school of thoughts from different people, what they say about this issue. Let's look at different school of thoughts. Okay. Faizo MC is like, a criminal is a criminal not until they are excused from a claim. Why you release someone who is claimed to be a criminal to be sent back to the society to kutija people again? That's not fair. But also someone who just abused someone cannot be given sentence of 14 years. Hey mama. So in other words, Ssenyonyi, in his submission, he wanted the court to release the Ssebuwufu on bail even before being tried. You get. But now you can see MC Faizo is like, a criminal is a criminal, not until. Hey, there is no way you can say a criminal should be released to the society before that criminal is tried. So that is what Faizo MC is saying. Then also we have Giant is like, impunity in the drive opponents targeted as criminals in the interest of the state for political stability, democracy, rule of law, better East African region, and Uganda at large. That impunity in the drive. Impunity in the drive. So you can see this is a foot soldier. Moses Walu. Okay. Under the Constitution of Uganda, power belongs to the people, and people have a right to demonstrate and remove an illegitimate government. So how did he incite violence in the people, and what evidence convicts him? So this one is like, under the Constitution of Uganda, power belongs to the people, and people have a right to demonstrate and remove an illegitimate government. So this one is like, there is no proof that Ssebuwufu was inciting violence. Basically, that's what he's saying. So do you think Joel Ssenyonyi was right to ask for the release of Ssebuwufu before being tried? Take a look in the comment section. Like, share, subscribe. See you in the next video. Peace.